Lachowski i Piątkowski o prawie międzynarodowym. Podcast Wydziału Prawa i Administracji Uniwersytetu Łódzkiego oraz portalu Obserwator Międzynarodowy.
Join the Global Law and Governance Bachelor's Program at the Faculty of Law and Administration, University of Łódź, and gain the expertise to shape global policy and build a career where law meets international impact.
Dear viewers and listeners, we would like to extend a warm welcome to you to another episode of the podcast Lachowski and Piątkowski on International Law. In today's episode, together with our distinguished guest, we will take you to Croatia, engaging in a discussion on international law, the most significant current developments in international relations, politics, and exploring Croatia's, or more broadly speaking, the Western Balkans approach to international law and international institutions. Today, our guest is Professor Mario Krešić, Associate Professor at the Faculty of Law, University of Zagreb, where he also serves as Vice Dean for Finance and Business. Mario, welcome to our show.
Thank you, Tomasz. Thank you for this opportunity to discuss all these important questions.
Yes, thank you one more time. And just a couple of words about dossier of our distinguished guest. Professor Krešić teaches legal theory, the theory of human rights, and the prevention of atrocity crimes. He holds a PhD in law, as well as degrees in law and political science, and has been a visiting scholar at universities in Italy, Poland, and Slovenia. In addition to his academic career, he brings extensive experience from public institutions and international organizations, such as Deputy Ombudsman of the Republic of Croatia, where he led the National Preventive Mechanism for the Prevention of Torture. He also acted as a special advisor to the Minister of Justice and held positions within the government of Croatia, including the office of the Prime Minister and Minister of Justice. Furthermore, Professor Krešić has collaborated with international institutions such as UNDP, the UN office in Brussels, and the US Department of Justice. And what is very interesting, also Professor Krešić participated in Croatia's EU accession process within the working group for Chapter 23, Judiciary and Fundamental Rights. And before I will pass the floor to my colleague Mateusz, one more thing, because University of Łódź that we represent with Mateusz and University of Zagreb cooperates within the framework of the unique alliance, that is European Universities of Post-Industrial Cities. So it is very great that we can explore this cooperation during our today's podcast. So once again, Mario, welcome. And right now I'm passing the floor to Mateusz.
Yes, thank you very much, Professor, for being with us today. As Tomek said, we are really appreciating this in a tough moment, I believe, for international law, or maybe international system, because we always try to highlight this division that we have international politics, we have international system, and we have international law. And my first question is a little bit general, because a lot of experts, journalists, politicians, especially during the latest Munich Security Conference and economical summit in Davos, they emphasized that the international order is falling. It's It's crumbling right now. It's non-existing. This post-World War II order that was established in Potsdam and San Francisco is being replaced by a new order. So my question is, are we seeing total destruction of post-1945 world order, or maybe we are seeing, let's say, a completely new world in which power will prevail over the norms, and we are maybe going back to the 19th century style of politics. So this is my first question, because we discussed it on almost every episode recently, this issue.
Thank you, Mateusz, for this question. Yes, we all heard about this claim about the end of international order. But if we are looking in the previous events, we will see that this claim about the end of the international law appeared recently after the Greenland case. And I think that this claim, this thesis is not correct. But what I think that is happening now, what we are witnessing now, is the gradual emergence of new international order. So the questions about whether particular acts of the states are lawful or unlawful are, of course, interesting. But I think there is more interesting question which is deeper one. And that question is whether these acts that we are seeing now in international arena, whether these acts are creating a new legal framework, which is different from the previous one, as you mentioned, after 1945, new legal UN legal order. So is it different than the old one? And whether this old one will disappear and cease to be the framework through which we are evaluate current events. So just briefly, I know that we all know, but just to remind ourselves on the events that happened in 2022 and later on, which are, I think, crucial for this transformation of the legal order, international legal order. So we all remember that Russia intervened in Ukraine in February 2022. Of course, we had one intervention before, but I'm focusing now on this huge intervention on 2022. And if we are researching what were the reactions to this intervention, these reactions of European states and other states was practically, there were arguments practically through classical legal framework. So the act was understood as violation of international law, and it was publicly condemned by most states. What we could notice at that time, that some states, especially if you are looking at voting in UN General Assembly, you can see that some states were very cautious, and even if they condemned the Russian intervention, they still were not so much against Russia. So basically they were indirectly or directly supported Russia as opposition to the West. So the next event that is important is, we all remember that Oval Office meeting on February 2025. It was the meeting between US and Ukraine presidents. And that was the turning point, at least for the Europe, because for the first time, unconditional American support to Ukraine, the Ukraine defense of its territory was no longer self-evident. And at that time, a degree of understanding for Russian territorial claims entered political discourse. So Europeans were shocked. Publicly, they sent a message, we have to keep the international order based on rules, although it is a question, what does it exactly mean? Then we have through whole 2025 economic war, basically the tariff war that United States escalated. And we have to remember that the World Trade Organization dispute settlement remained blocked. So there is no basically international organization, international dispute resolution for the questions whether these tariffs were basically legal. We had during 2025 Gaza, Palestinian-Israeli war, and Ukrainian war with massive civilian suffering and destruction of civilian infrastructure. Then what we have in January 2026 is United States intervention in Venezuela, which basically triggered only limited reactions. We remember that Europeans basically were not so much against that intervention. They didn't question that, even they provide some justification for that. But then, shortly after that, a few days after that, we had the Greenland case, where basically Washington openly signaled its intention to acquire Greenland, even at the costs of NATO cohesion, and supported that ambition with tariff threats against Europeans. That was I think, in my opinion, the main moment when the thesis about the end of the international law appeared, or at least it was spread dramatically. Of course, recently events, intervention on Iran started on 28 February. Something interesting happened there regarding justifications. For the first time, we can hear that United States they are trying to provide arguments based on international law, the old paradigm, like why they intervene, self-defense, and other arguments, which were not present in Venezuela case and Greenland case especially. So I would say that international law existed before the United Nations, before this United Nations system that we know before, that we know now, but it could also continue to exist even if UN disappeared. But it would not be necessarily the same law that we know today. So, in my opinion, conceptually, international law would truly disappear only if states no longer felt any need to justify their actions in legal terms. So the argument, I take territory because I can, is not legal argument. It's a pure statement of power. As long as states seek legal justification, law remains relevant, even if weakened in relation to what we had before. So this is my opinion, that that international law will not disappear. We had UN system of international law. Before that, we have, as you mentioned, 18th century perception of international law, but still international law exists. We have these changes in 17th century. We all remember the story about Westphalian peace treatments, and we have international law even before that. So international law will remain, but we will have serious changes, in my opinion, in the content of that law.
Thank you very much, Professor, for your first comment. Yeah, it is very, very interesting to see those legal justifications. However, as we agreed with Mateusz, I will leave this question for him for the next round, and also I'll try to make this kind of follow-up, because you mentioned the European perspective. Very often today's critics of international legal order, they are saying that that international law, or something that remains after international law, it is a kind of return to the law of the stronger. And what is the place actually of Europe, or especially the European Union, within this global balance of power? Because as you mentioned, in terms of Venezuela, many states were reluctant to condemn openly. In terms of Iran, there is this tension between US and Spain, for instance. But at the same time, German Chancellor Friedrich Merz, when he was in the White House just a couple days before our recording, he said that, yes, we as Germany also want to get rid of this Iranian theocratic regime. So how do you understand the position of the European Union, especially whether still does the EU represent this kind of genuine normative power shaping global rules, or is it ultimately dependent on strategic or geostrategic or military strength of others, as the US or China or Russia?
Thank you, Tomasz, for this interesting question too. First of all, I would say that in this transformation of the legal order, we have several indicators that this is happening. One of them is this theory, I would say, on spheres of interest, zones of interest. It's very interesting doctrine, and I think although it seems like now it is tested, I think that we should be very careful about that. because this zone of interest basically means what? It means that if you have this zone shaped by the borders, I don't know which states are in one zone, which in other, which in third, it means that other states outside that zone cannot intervene in that zone of states. But it also means that at least some states or all states in the zone can intervene in the business or in the affairs of each of the states in that zone. It's very interesting, I would say. I think that we are going to, that the world is going to go in that direction. Not necessarily that we will finish there, but I think that it means, first of all, what zones will be created, because you could have the, I would say, goodwill and badwill states. And if you are as a state in badwill zone, it means that maybe you will be exploited, your resources will be exploited, and maybe it means that you will not have sovereignty, discretion. You all remember that from the situation before the 1990s when all this changed with the end of the bipolar world. Now, regarding this question on powers, I would say that still we have these main powers. It's obviously United States, China, it's Russia and Europe. And when I said Europe, I mean some European states or EU3 states, which are the most important. And this structure of power is reflected in Security Council, because in Security Council we have China, United States, Russia, and Europe, meaning UK and France. So I think that the question of power always remains, because law does not exist outside the society. Even national law is appearing from the society and the power relations. So it's also an international law. International law appears from these relations of power. The only difference between national and international law is that in national law, all of us are aware that I'm not the most powerful and that I'm vulnerable, and that if I don't respect other interests in my community, sooner or later someone can kill me or destroy me, or so I have to cooperate. In international arena, the situation is that you have strong powers, which at some point seems like untouchable. So what is the answer to this situation when you have less power states, like small states or middle power states? First, the question is, what will these big political powers decide to do? Because the whole design of UN system is basically designed by the winners of after the Second World War. These states are, the system is created that these main powers have immunity in a way that they can conduct a war, but no one in the Council of Europe cannot say stop, because there is a right of veto. So we pretty much depends on the will of these great powers, and some powers like Europe can be goodwill and try to protect weaker states and maybe to reorganize the legal order in better sense. The second is the capacity of smaller and medium-sized states to reduce dependence on these great powers. And this is what basically Canadian Prime Minister said, and what he was trying to do. He said, let's the middle-sized and smaller-sized states, let's see how we can cooperate and find different models so that we are not dependent on one great power. And the third way how to play this game of power and what other states could do is basically to show that these great powers themselves are vulnerable. Because if they are vulnerable, they are ready to cooperate. And I think that what's going on in this conflict between United States, Israel, and Iran is that Iran is showing that these great powers are also vulnerable, and that with these distractions around, they want to show, look, we are important because we also can make the mess. Regarding the Europe, it's obvious that Europe, at least in discourse, is weakening. I think that it's not the problem of Europe that we are consisted of states, national states with sovereign states, but the problem is that Europe is not recognizing the strategic interests of Europe as such. So we have these stories with Brexit, exit, with the influence of other great powers towards separate states. And I think it's a dangerous situation for Europe. For me, it's natural that we Europeans share joint our destiny and that we cooperate together. Because if we, in a way, accept this kind of discourse, and if we don't show somehow the power of Europe to be jointly on the same line, it means that other great powers will play with European states. I would also mention this: if we have these four great powers, including Europe, we could see that this conflict between Europe and Russia is basically makes difficulties for Europe and Russia, while United States and China are pretty much fine with it. So this conflict for Europeans and Russians, in my opinion, is not something that is contributing to their interests. And I think that should be somehow changed. Of course, the war in Ukraine should be resolved, and the question is how. I still believe in these legal arrangements that can be proposed in resolving the Ukraine-Russian war.
What you mentioned also about the coming back to the, let's say, more global perspective, you mentioned the speech of Canadian Prime Minister Mark Carney. Then I believe he made a rare example of auto-reflection among Western politicians, that he basically acknowledged that the international rule-based international order, the famous, I would say, phrase, sentence that was in use since 2022 has, would say, very problematic content. We don't know what is really, and he maintained that it was a fantastic illusion in this regard. Also referring to another speeches regarding the maybe not Davos, but rather Munich Security Conference, I believe the president of Finland, Alexander Stubb, mentioned that we should move, paraphrasing kind of his words, that we shall move from rule-based international order to the value-based realism in international politics. So I think this is also quite significant that those Western and mostly liberal politicians are acknowledging the necessity of shifting at least the rhetoric, because we know, we kind of understand the rhetoric does not necessarily follow the words, and I think that was the main part of the Carney speech, that he acknowledged that our words were not catching up with the reality. And in this context, if we are moving from, let's say, this liberal approach to more realistic, and there has always been a clash in theories of international relationship between realism and liberal approach, I would like to ask you a question about, let's say, the most predatory move the state can do, namely acquisition by force of the territory of another state. Something which, from the perspective of the law, is, unbelievable, or basically, I would say this is the probably most important rule of international law in terms of international peace and stability. You cannot seize the territory of another country by force. Yet, as you mentioned about Ukraine and the peace process, we are seeing this tendency. I think we are seeing the trajectory that there is a chance that we will have to burn this principle for the sake of, let's say, peace and stability. This is, let's say, what is being suggested in the media, in the press, because on one hand, you cannot really reconcile the principle of territorial integrity, sovereignty, with some demands that are directly threatening this territorial integrity. But to finish my question, Ukraine is one thing. We have moves on Venezuela, we have moves on Greenland, and now Iran. And out of those interventions, as you said, international law will be still relevant if there is some legal justification and if the states are still aware that there is explanation need to be given. It's quite paradoxical to me that actually the most, I would say, comprehensive, but of course false, justification was probably provided by Putin on his speech on the 24th February 2022 when he announced the aggression against Ukraine, when he made this quite sophisticated picture that those republics, self-proclaimed republics, ask Russia for help, and Russia is collectively self-defense, acting in self-defense. He even directly invoked Article 51 of the UN Charter. But as we move further, we don't see much justification later. That what we are seeing in the context of Venezuela on the UN Security Council, that, well, this is law enforcement operation. It has nothing to do with Venezuela or Venezuelan people. And just ahead of our talk, I just read a speech of Mike Johnson, the Speaker of the House of the U.S. representative, in the U.S. Congress. He said, we are not in war with Iran. So obviously this is the international humanitarian law, but nevertheless, we are seeing that by denying certain, facts going on, we are also, I guess, closing the room for legal arguments because it's quite easy in this regard. And I wonder, what do you think that we kind of try today detach from reality and said, we are not at war, this is not aggression, this is the intervention, or maybe in context of Iran, we could wonder, this will be a question of Tomasz, maybe this is some kind of humanitarian intervention. And what is your thought on that?
Well, thank you for these questions. First of all, I would like to say that in legal theory, we have also different models of international law. And I will just mention the rule-based international order, which is probably what these politicians are meaning. A rule-based international order is pretty much, empty. It's like it's a meeting of two. It's a connection between two states where one state and another state are making a contract, and one state, the first state, is trying to get as much as possible from this contract, if possible everything, and the other state is also trying to do the same. So it's like reciprocity. There is nothing more than let's have a contract and this is our cooperation. There is something more above this kind of idea of international legal order. This is the legal order based on principles. And this is much more than making a contract and getting the benefits for myself and for yourself. It means that you have some basic principles and that you are trying to build the community of states based on principles, even if that is not something that you are going to benefit from. So international community as an idea above the states themselves. So as I mentioned at the beginning, I think that the most important thing now is to have any justifications for acts of the states, and to be careful and to evaluate what these states are offering us as justification. I don't think that on long term, any kind of realistic politics based on power, and yes, we can do whatever what we want because we have the power, can remain. We have the history where great empires disappeared because of this idea. I think that the kind of reasoning of what you are doing connected to international order as something that exists above the states is important. So when we are looking on these justifications, let's see Ukraine first, because this war between Ukraine and Russia, what Moscow is basically offering what I found is we intervene because we want to protect Russian community there. That's the first argument. The second argument, denazification of the country. Then the third one is national security in context of these zones or spheres of interests. But I think that these arguments are not sustainable because international law and arrangements, different arrangements, you can go to Croatia, to other countries and find how national minorities or even communities can be protected in a way that they will be safe and that you don't have to intervene to protect them. I would just remind that the war in this region started with this idea of other states intervening in other states with argument we are protecting our national minorities there. So I think that this argument is not something that is good in legal reasoning. And also what we can hear, and this is interesting, like these historical arguments, we are intervening because historically that was the part of our empire. This is something that returns us really to the 16th century. So I don't see any good argument that me, as I don't know, as much as possible objective, would persuade me to accept these arguments. And in Ukraine, no one would accept these arguments. So I think this is not a good way how to resolve the issues from the Russian side. At least they could offer something. For Venezuela, it's interesting because it was basically the main argument was we are hunting a criminal, where the president of the state is not it's not the real president of state, but he's a criminal who is doing criminal activities for his own purposes. So you have the military action to arrest a person who is not recognized as a criminal and bring him to the justice, to the court in your own state. We all remember Panama case. We all remember Eichmann case. In Panama case, from the perspective of international law, it was illegal act because the General Assembly, UN General Assembly, basically said it is not a justified intervention because you cannot intervene in such a way. For Eichmann case, it was similar because although there was reasons to arrest a Nazi person or leader there and to bring him to justice, it's from the just cause is okay, but from international law, it was not legal. So this kind of articulation of arguments, it reminds me on this idea that we have pirates all around the world, and there are some presidents and some people that are claiming that they are presidents, but they are not presidents. This is not normal states. They are criminals, terrorists who are basically exploiting their own people. It's interesting argument, and in the United States history, you will see these arguments about pirates and how to justify your interventions based on this argument, even the pirate states. So Venezuela was not a state, but a pirate state, so we can intervene. Regarding the Greenland, the reasons that were offered there, regarding Venezuela, the obvious argument was we are protecting the health of Americans because they are importing the drugs in our country, we have to stop that. This is the argument like my interest of my people and I'm going to protect my people. It's still not the protection of the legal order itself. Then the arguments in the case of Greenland, zero. So what is interesting that there were some possibilities for justification. Maybe the Americans could say, yes, Greenland, it was a colony before, because it was like a colonial issue. They have the right on self-determination. So let's go in that direction. Let's allow Greenlands to decide for themselves what they want. No, the only argument was it's important for our strategic interests. That's all. In Iran, the kind of argumentation that was provided reminds us of arguments that were provided before all these shifts. in international order. And arguments were basically, let's destroy nuclear program, weapons for mass destruction. We can remember these arguments before, chemical weapons and so on. Okay, this can be like an argument that you can offer. The second argument was like in Iran, you have leaders that are basically doing mass atrocities over their own population. That could be the serious argument in Venezuela and Iran, but the question is how to see whether these ill treatments of own population pass the threshold for intervention. And the third argument was basically self-defense, as you mentioned, Article 51. Now we have the problems here with the justification of intervention based on that, because it's not immediate, immediate attack that was expected to happen, because the United States, Israel are talking about that Iran was planning to attack them. So it was very not so good argument. And then you have this even more dangerous argument on preventive war, where you can go to the war because to prevent something that will happen in future. We all remembered that this kind of arguments on preventive wars were not good in the history. It was the argument of Germany attacking Poland in 1939 with this idea and argument, yes, we attacked them because they were planning to attack us. So all these arguments, in my opinion, are not good for the serious players who wants to show something to international community, who wants to attract other states in their zones of interest. It's more showing to all of us, look, it's not something serious. Basically, they are doing geostrategic game and trying to provide whatever. Sometimes they're not providing even good arguments. I think that the main problem here is that in this shift to new world order, the theory is missing. The justification for the acts is something that is missing here.
Yeah, okay. Thank you for this insight, because you talked a lot about, maybe not a lot, but quite a lot about also mass atrocities. And it brings us to the question of something which is it used to be called as a humanitarian intervention, or in this paradigm, let's say, framed in 2001, firstly by the Canadian report and then by the UN Works responsibility of to protect doctrine R2P. It very often, by many experts, very often it is seen to be a kind of a product of a liberal way of thinking of international law and international relations. And I think that's one of those peaks of the R2P was the intervention based on the UN Security Council resolution in Libya, when the R2P as a concept, as a doctrine was introduced. I think for the first time, this kind of military resolution issued by the UN Security Council. However, you mentioned also the Russian aggression against Ukraine, this first phase after 2014, so the annexation of Crimea and the outbreak of the war in Donbass in the east of Ukraine. During that time, Russia has actually used this concept of R2P to justify its intervention for the protection of people of this Russian-speaking minority in the east of Ukraine. I even remember the article written by Mark Kirsten on his blog Justice in Conflict. The title, it was R2P, Russia's R2P in Ukraine. Don't buy this stuff. So how would you actually assess this doctrine of R2P today? Is it something that is really, let's say, normatively viable in terms of its normative framework for atrocity prevention, or has it become politically unworkable because of the situation after 2014 and then after 2022?
Thank you, Tamas, for this question. Also very interesting. First of all, I would say that this world order that we have after the 1945 was designed to stop the wars between the states. And it was very successful, and it's even successful today, because if you are looking how many wars between states we have today, it's like less than 10. In 18th century and before, we have much more wars and territorial acquisitions based on conquest. So ideas are important, and basically this is the main idea that we have, at least till now, that non-intervention. So you cannot threat to other countries and you cannot intervene in other countries. But on the other side, UN is also based on human rights. It's based on a very simple idea that we don't want to have the order in peace where we have states basically doing what was Nazis doing in the Second World War to their own population. The idea of R2P is very simple. I think this is it's very much criticized doctrine, but I don't see the better one. I don't see that anyone offered something else. So it's doctrine which says basically three things. It's a minimum for developing of legal order. First thing, our first pillar is the following. Every state has responsibility to protect its own population from mass atrocities. And mass atrocities are ethnic cleansing, war crimes, crimes against humanity, and genocide. Basically, this is the minimum. If we cannot agree on this, I don't know on what we can, as the states, agreed on. So Croatia, other countries, Russia, United States, it's not the sovereignty that is the most important thing. Sovereignty is important, but it doesn't give you the right of discretion to do whatever you want inside of your borders. You have to protect the population. And when I say population, doesn't mean nationals of one nationals and not others. Population or territory. That's the idea of the international law itself. International law basically separates the whole globe in states and basically provide discretion to states, to authorities to control population and to have order in that territory. So basically, this is the tension between sovereignty and protection of population. The second pillar is, if we all agree that non-states, non-authorities should commit atrocity crimes to its own population, the second pillar is, what about when the state is not able or capable to protect its own population? The second pillar says international community, states, UN, and organizations have to provide assistance to these countries. And these countries which are failing to provide protection, they should accept this assistance. The third pillar, if you have manifestly failing states in protecting their own population, you can intervene. You can intervene economically, diplomatically. That's all kind of interventions basically in states. It's not classical intervention. And at the end, you can intervene militarily. Yes, this outcome document mentions that you can intervene only through the UN, meaning that you have to have the authorization of Security Council. So it's important to remember how this doctrine, first theory and doctrine, appeared. In 2005, it was the World Summit, all leaders of the world, the larger gathering of the leaders of the world ever. They all agreed, 191 member states, that they agreed on these principles of R2P. Principles accepted by UN General Assembly, later on accepted even by the Security Council, meaning unanimously by all permanent members, Russia, China, UK, France, United States. They were all for R2P principles. I think it's something that can bring all states together. But we have to remember what happened before. As you mentioned, in 2000, there was a commission, International Commission on Intervention in State Sovereignty, established by Canadians, Garrett Evans, and some others. also from Russia, from India, Australia, South Africa, other important countries. They were academics, diplomats, were the members of that commission. They provide this report, R2P report. But why? Why this commission was established? We have to go further. Because there was a problem and that politicians could not resolve, that there were many humanitarian crises in 1990s. Remember Srebrenica, remember Rwanda, remember Kosovo. So in 1999, there was a huge danger that, at least according to information, that mass atrocities would happen in Kosovo. And then NATO intervened in 1999, stopped that by bombing bombing campaign against Yugoslavia and ended war. So people say, yeah, it was not illegal, but they mentioned at least it was legitimate operation. But why again commission? It was Kofi Annan, the UN Secretary General, who basically posed the question. And he asked the following: if international humanitarian intervention is an assault on sovereignty, how to respond to Srebrenica, to Rwanda, to all these cases of systematic and gross violation of human rights that basically is against any precepts of our common humanity. That was his words. And that was the trigger for later on to come to this doctrine. Is it, yes, you're right. I think it in this period, 2005, 2011, it was even legal doctrine because it was used by the Security Council. Then we have Libya and the fall of the consensus in Security Council. After that, not implementation in Syria, Myanmar, Sri Lanka, and other countries. So problematic. From something that was emerging as legal norm, we have the situation that basically that norm could be that. In meaning it's not anymore legal norm, and now it's the question whether other countries will follow that. In my opinion, this doctrine still has the future, but it has to be implemented as it was designed. So we have to avoid this situation, and any states can provide arguments on R2P and says, yes, other countries doing atrocity crime, we're going to invade, but it has to be something that control when this doctrine is implementable and when it is only fake argument to intervene. Ronald Dworkin, a legal theorist, proposed this imagination. Let's imagine that we have an international court with the capacity and the jurisdiction to decide when these mass atrocities could happen or are happening, and then after their decision, the states can intervene. I know it seems like something illusion, but I think it's possible in future to have this doctrine again in life.
Really interesting to hear your viewpoint on R2P. I think a doctrine which is still somehow active, but nevertheless, it's hard to say whether the states are thinking anymore in the future about the humanitarian intervention in the R2P, because as we mentioned before, some constructions could be used in good faith and bad faith. And unfortunately, the R2P is, you mentioned that, were used in justifiable circumstances and also in circumstances that does not hold with the reality in this regard. But nevertheless, it was used, as you mentioned before, as a justification to intervene in this regard, to the detriment of the doctrine, which is very noble, as you mentioned, at its core. And it's probably the only alternative to respond to atrocities that are happening on the state territory. But nevertheless, I would like now to move to talk a little bit about Croatia and the Croatian viewpoint on international law, because in this podcast we also met with scholars with our region, Central Southern Europe as well, different areas, geographical. And we also wonder, what's the viewpoint of Croatia on the international law? We, especially Tomasz, is a big fan and a highly engaged scholar of what we could basically named as a second world approach to international law. So approach between so understanding that on one hand, we are not the part of the West, we are not the part of the East, we are not the part of the global South, we are the periphery. And what's our role as a periphery in this regard? So yes, I wonder about this, and also because I think my question could connect to the to next question. I'm also very curious about how Russian aggression against Ukraine is being perceived by Croatia. Is Croatia, because obviously the situation in Poland in terms of geopolitics, this is conflict which is taking place just at the border of the Poland. And because of the history, Poland is very engaged in this conflict. I wonder, because obviously Croatia is a little bit farther away from what's happening in the Ukraine. What is your consideration of a place of Croatia in this conflict? Because maybe a focus of Croatia is rather to the south, maybe Mediterranean Adriatic Sea is more important in this regard, and some threats that could come this way, or maybe there's still, I'm not sure, maybe there is still some kind of uncertainty what will happen with Bosnia. Whether this project that was established after the Dayton Conference is going to survive, or is it going to, let's say, reignite something that happened in the past? So I'm wondering what's the Croatia role, because from the Polish perspective, to be honest, Croatia is being considered to be in quite, I would say, favorable geopolitical position because it's far from Russia. In this regard, it's like surrounded by friendly nations living in NATO or in European Union. But on the other hand, I wonder, is it also perceived this way in Croatia itself? Because it's kind of interesting whether the place in the Europe and in the world of Croatia is a blessing or is a curse. That's really what is quite interesting for me.
Thank you. Lots of interesting and difficult questions, but I will start from the middle. You mentioned you mentioned the question, what is the position of Croatia towards Ukraine in this war? I have to say that basically we have to remember the historical context in which Croatia emerged as the state. We have to remember that Croatia was part of the Union of States, Yugoslavia. We have to remember that Croatia was involved in war in 1990s, and that we have lots of casualties, lots of human life lost, and lots of destruction of civilians also in Croatia. And the Croatia was fighting for its independency. It was not something that was given to Croatia. It was something that Croatia had to fight for. And in this context, I think that Croatia as nation, as population, is very empathic to Ukrainians, because they feel this is the same story. And what it helps to us now is, okay, you understand Ukrainians. If you understand Ukrainians now, you can understand Croatians in 1990s, because it was pretty much a similar story. So Croatia, from this position of the past, of the history, is very much for Ukraine, because they can see that this is aggression. From the perspective of Croatia, it was the same aggression like of Serbia, Yugoslavia, on Croatia in the 1990s. Croatia was even in a difficult position because we didn't have, we had embargo on military equipment, we have to fight for ourselves and so on and so on. But the important thing, for example, is that Croatian leadership is saying that not peace without justice, and no peace in Ukraine without territorial integrity. So Croatia is very much in this war for Ukraine and offering some legal arrangements how this conflict can be resolved. The question about the region, yes, this was the region of 6 republics of Yugoslavia. 2 of them are today member of EU, Slovenia and Croatia, integrated in European Union successfully, and NATO members. Now what we have and what is called of the rest states Western Balkan, which means other states and Yugoslav states and Albania, is basically that we have the states like Northern Macedonia, Montenegro, Albania, which are NATO members and wants to have their path integrated in NATO and EU. You have Kosovo with the problem of recognition, and some states recognized this state and others not. Serbia with very, I would say, bipolar position. They're trying to, on one way, to be with the EU and NATO, on the other side, to be in good relations with the Russians and others. So geopolitically, this part of Europe is always interesting because you never know what will happen. As you mentioned, Bosnia and Herzegovina, it's a complex state with complex situation with the ethnicities there. But what I would like to say is also that this region and what happened here shows us that at the end, legal arrangements, maybe they're not the best, but maybe they are best at the moment, can be offered and can resolve the conflicts. So if we could have all this, what we have today in this region in 1990s, we wouldn't have the war. So today we have Croatia, Slovenia, the states independent. Why couldn't we have them in 1990s? We have Bosnia and Herzegovina with this complex structure, asymmetrical federation. But look, maybe this is the best solution that could be made in these circumstances. And interestingly, Bosnia and Herzegovina and their constitution is based on the international treaty. There is lots of things that we can learn from this region and these legal arrangements which can be used in other parts of the world. At the end, you asked me about Croatian position in general towards the international law. Croatia is very open to international law because it feels as a small state that only protection, real protection, can come from the international law. But we are very pragmatic. We are not naive. What we learned from our history, that international organizations are important, but sometimes they are very slow. They don't understand the real situation. It's not something that I'm claiming that Croatia is wrong, others where Croatia was right and other states are wrong. The current situation justifies that Croatia, Slovenia, and other countries were right when opposing the unitary states of Yugoslavia and fighting for their freedom. But we have to remember that even at that time, Europe, not European Union, the European Economic Community, was very slow. They didn't know how to respond to Yugoslavia. And basically, United States resolved all this situation in this area with their intervention there. Croatia is not is very sensible for interventions. Croatia is respecting sovereignty, territorial integrity, but we would very much like that someone intervene in this region and save us from aggression in time when we were attacked. So we would very much like to see Americans and Europeans defending Croatian freedom and human rights. On the other side, we have this experience with atrocities in the region. We have the experience with the International Criminal Tribunal. We accepted the jurisdiction of that tribunal. It was very sensitive because by accepting that, you don't know how these judges are going to behave, what are going to provide as their judgments. And we can look at the legacy of ICTY and say, look, this was like many things were not good for Croatia, but at the end, Croatia supported this international adjudication, these international courts. I think this is also part of Croatian history, and it's something that we can offer. We don't agree with everything, but we shouldn't say that this was like a very bad idea at the end. So international adjudication, international organizations is something that Croatia is very much accepting. It's not that we are Croatia first doctrine. We don't have this kind of language. We are very much for cooperation, trying to find solutions for all states in the region and globally. Of course, we are not naive, as I said, because we could see that sometimes international organizations, international leaders are not playing for international order and for the just cause, but sometimes they're playing for their own interests. But this is not the reason why to stop in trying to build better international organizations and better international institutions.
Yes, so we are slowly but ultimately approaching the end of our discussion. But before we'll finish, let us address the last question, a very difficult legacy of Croatia with the war of 1990s and the lessons learned by your state regarding international justice and atrocity crimes. Before I will ask you this question, I would like to recall my own conversation I had at the Ukrainian Ministry for Temporarily Occupied Territories. I conducted research there and provide an interview with the Deputy Ministry of Temporarily Occupied Territories. It was several years before Russia's full-scale invasion, but of course after the annexation of Crimea and the outbreak of the war in the east of Ukraine. And during this discussion, I was told by the Ukrainians that actually Croatia's experience in the reintegration of occupied territories was very extensively an inspiration for Ukraine how to shape its own policy toward reintegration of Donbas or Crimea in the future. So it is also very interesting how this experience can be shared in different countries, of course, of Europe, but still in different countries. So my question is, how do you see this, let's say, transitional justice experience, legacy of Croatia in terms of the cooperation of Croatia between Croatia and the ICTY? You said about the ICC. So what's your assessment of this Croatia's legacy of the wars of 1990s?
Thank you so much for this question. But before I start, I just want to mention that the international community at that time in 1990s were totally different than what we have now. UN was respectful. United Nations were a respectful organization. ICC was also something that was important, and all these criminal courts and tribunals were seen as something that exists as the fact. Today we have a situation when UN officials are announced as persona non grata. They are not respected. ICC judges are basically sanctioned by national countries. So the situation is very different, and I don't see that as a good direction of development of international order, because I think at the end there's international courts, especially criminal courts, is something that is important, that was invented at one point after the Second World War, but even before. Americans basically were the advocates for arbitrations and all these kind of dispute resolutions through the courts. Now, regarding this experience, you're right. Croatia had this military operation which ended the war in Croatia and in Bosnia, and reintegrated these parts by military force, but it didn't use the military force for the other occupied parts, Eastern Slavonia, and this reintegration of Eastern Slavonia was the most successful UN peacekeeping mission. Basically, you will not find such success of UN like this one of reintegration. And there is experience of some people that were involved in this situation how to do it. Even today, Croatia is very much sensitive for this issue and very much aware from what we have from the history. And today, the national minorities' rights are respected at high level. Institutionally, for example, we have reserved seats in the parliament for the national minorities. That's something that only few, I would say 2-3 countries in the world have like reserved seats for the minorities in the unitary states, not in these multinational states. And these kind of experiences are very much useful for Ukraine. Also, these things with atrocity crimes, because what we experienced in this region and Ukraine is not only that you have the war aggression, but you have atrocities. One thing is to kill the soldier because you're shooting on him. The other thing is went to the village and rape the women and kill all people and destroyed the infrastructure and destroyed the cities. What we're seeing, I don't know, on TV, that this kind of destruction on civil infrastructure and civil population is huge in Ukraine. It was huge also in this area. That's something that is not acceptable. And we know all that war crimes and atrocity crimes can happen in war on all sides. There is some kind of logic, but it is important who started first, not in the sense that it justifies the other sides, that they can do the same, but it has some kind of importance. And also when you see the scale of mass atrocities, whether it's sporadically or more, or it is systematic. So yes, Croatia accepted ICTY. We have to face these war crime trials in Croatia. We established witness victim support, which is also like innovation in Croatia, which started with protecting the witness and witnesses of war crimes, and today it's support to all victims and witnesses in courts. And we know that victims and witnesses are important for telling the truth. What really happened. If you don't have witnesses, you will not have cases. At the end, I would say, yes, this is the part of, I would say, long-term peace. It's not only that you stop the war, but you have to think how to build the long-standing peace. And these war crime trials are important. It's important for victims, first of all, because if they don't have justice, then it's not something good for them, and it's not good for society. And it's always dangerous that something will repeat again in the future. So in short, yes, Croatia has this kind of experience, and I know that Ukrainians are using this experience for their situation to think about the future and to think how to provide just and long-standing peace.
Thank you very much, Professor. And unfortunately, our episode has come to an end. So just a short summary. When I heard especially the last part, I thought about the 90s, the era that we call it the peak of American hegemony, the end of the history, the Pax Americana. And obviously the Pax Americana, it didn't mean that there were not any wars around it, because in the 90s we have this absolutely brutal conflict in Yugoslavia. But on the other hand, we could see how important is friendly, let's say, international environment, that the institutions were strong, and at least there were some consensus, more or less, in the world at the time, that some actions had to be undertaken. Some, let's say, pathway to peace and, let's say, transitional justice have been approached. So I think many noble things were created, developed, and understood in the 90s. And I'm not sure whether we are going to see those constructions being restored. Maybe we just need to face the reality that politics and the law operates in a cycle in which we have catastrophe, then we have the return to international law, then we have a moment when this law starts to collapse or somehow diminish, and then we have a tragedy, and then again a restoration of international law. I hope it's not going to happen, but unfortunately a lot of indicates that that might be a path. But nevertheless, thank you very much for sharing this very interesting perspective of Croatia road to European community, to how to deal with the past, the difficult past, and the Croatian approach to the modern problems. So once again, for being here with us, that was a great pleasure.
Thank you very much. It was a pleasure for me, and I hope that we will have more opportunities to discuss and to cooperate between our scientists at the end in Poland, in Croatia, and other countries, because at the end of the day, it's important for what we as scientists, legal scientists, political scientists are talking about. And it's important not to fall in this kind of discussion only about realistic policy. Look, it's happening, the power is there, we cannot do nothing, because we can. We can talk about what is reasonable, what is not. We can show to the path of developments, and I think we should never give up on this idea how to make the world better. I know it sounds like idealistically, but if we give up, then the only alternative is power, the zone of interest of the zones of powers of interests, where the small states and large middle scale states will not have a good future. We don't have to believe that if we give up in that way and not trying to build better world and try to ask for justification why you are doing this and not that, the future for us will be better. Because in Europe, we witnessed that this kind of my country first ends up with the occupation of European states themselves.
Indeed, thank you for these words. Even we can recall the sentence of one of the former Estonian presidents, who said that for small and medium-sized states, international law can be kind of a substitution for even a nuclear bomb, because we don't have nuclear bombs. Poland is trying to, get into this France nuclear sharing program. We will see if it succeeds. Nevertheless, we don't have our own bombs, but we have principles, as you said, principles, not just rules in terms of contract rules, but principles, values that shall be the basis of our international legal order. Okay, so just one last time to remind our viewers and listeners. Our today's guest was Professor Mario Krešić from the Faculty of Law at the University of Zagreb, Croatia. He serves there as Vice Dean for Finance and Business and has extensive knowledge and experience from different public and international institutions and organizations. So Mario, one more time, thank you for joining us.
Thank you very much, and I'm looking forward to next opportunities for our cooperation. Thank you.
Thank you. And one last thing, because actually our cooperation with Mario started with my visit to Zagreb a couple of weeks ago within Erasmus Plus program. But just to remind also our viewers that our universities are within this chain of unique universities. So hopefully we can cooperate more in different dimensions of scientific and other ways of collaboration. Okay, so dear viewers and listeners, thank you one more time for the support for our podcast. We appreciate every kind of comments, likes, and subscriptions. So please do not forget about our show. We will come back with another episodes either in English or in Polish. So one more time, thank you all that have listened to this episode, and see you, and we can meet in another episode of the podcast on international law.